So starting with the most important definition of the Designs Act, Section 2D. So this is the definition of a design and what are the rights that are protected under the design. So design rights basically protect the novel features such as a shape or a configuration, the color combination, the surface ornamentation, composition of lines or patterns of an article, right? So this can be in either a two-dimensional or a three-dimensional, or in either both forms where such aesthetic element is required to be protected under the designs. So this can be done by an industrial process or which involves, so these industrial process can include a manual or a mechanical or a chemical process or mix match of either of these processes to achieve the final design product. And there are certain things which are excluded, which are not protected under the Designs Act, which is basically a mode or a principle of construction. How you achieve that design is something which is not protected. So anything which is in substance or a mere mechanical device is not protected. For example, a screwdriver or a wrench, right? So anything which is basically performing a function of a mechanical device is not protected. Also, specifically, it is mentioned in the definition of a design that anything which is described as a trademark in the Trademarks Act of 1999 and which is mentioned in the Copyright Act as an artistic work, or a property mark which is defined in IPC section 479, which would be now be in the amended act, you would see that it will be referred to as the BNS. So these are the articles which are not protected under the Designs Act. So any trademark, which is the name of a business to indicate the goods and services, or to be identified as a source of a service or a good, this is not protected. So anything which is related to Copyright Act for to be mentioned in artistic work is also not protected. A simple example is of a trademark would be the Nike swoosh. The tick sign of the Nike is not a design, it is a trademark. This is a very, very important definition which has multiple parts, basically telling you these are the things that are protected under the Designs Act, and this is the process where you can achieve that design, and this is what is excluded, which is not scope of protection of a design in India. Now, what is a registrable design? This is also very important. So a design should be either new or novel, meaning that it should not be previously published. Okay, so anything which is existing in public domain, which is already part of public knowledge, which exists out there, does not or cannot be granted design registration. It should be new or novel in terms of aesthetic value to a design. Now there is a clear distinction between the shape of an article, right? So that is solely judged by the eye, does not mean what function that article is performing. Functionality part is something that is not covered in India. So we do not have the concepts of design patents in India or utility designs in India. You only have the concept of aesthetic protection of an article. So a design must appeal to the eye. The appeal need be either artistic. Or aesthetic, provided that some appeal is created by the distinctiveness of the shape, pattern, ornamentation calculated to influence the consumer's choice, right? So these are few examples that you see on your screen which basically embody different designs. So a wristwatch can be of a different design. A faucet in your washroom or your kitchen can be of multiple different designs, right? It only performs the function of making the water flow out of the tap, but the design of that product is something which basically appeals to the customer to buy it. It has an aesthetic value attached to it. So similarly, this is just a part of a car part, which is basically a headlight, which is also forming part of the complete design of a motor vehicle, right? So this also can be individually protected as a design, a unique shape of the headlight, And next you see is these are the beddings that have been embodied with different patterns, right? So these are different examples of where design can exist, and the basic requirement is to fulfill the criteria that it should be new or novel, should be original. It cannot be something which is already out there in the market. So next is Locarno classification. If anyone who's aware of trademarks, they would know that there are certain classifications to categorize certain goods and services. And a similar type of classification is also there for categorizing the types of designs or of products in certain classes, right? To basically put certain type of goods in a particular class. So it becomes very easy for the design, or basically a harmonized system for every convention country to follow one single classification. From point of view of exam, these are the important information for you to remember. So Locarno classification is an international classification for industrial design that came into being as part of Locarno agreement. So Locarno is a geographical place where this agreement was initially signed, and it has 32 classes of goods. So there are different types of goods classified into 32 classes. And India will officially enter into force on the 1st of January 2025. We have been following this classification for the purposes of categorizing the designs in India. And India is the 57th member to be now part of Locarno Agreement, which was signed on June 7, 2019, when it formally incorporated the classification and is part of its IP regime. And now this change will also be incorporated through the designs rules which were amended in 2021. So a link will be mentioned to you in the chat. This link, you can keep it with yourself, bookmark it. I would suggest that you revisit this link few times in a week, so that you get you get accustomed to understanding, like, this is how classification affects the categorization of the goods. So certain class would have certain type of goods available in them.
Now let's come to filing of a design application in India.
So this is a very important topic for everyone. How do you actually file a design application in India? What are the important details that you're required to remember while you're filing a design application? And what is the exact document that you will use to file a design application? That is also very important. So who can file the design application? It can be different type of entities in the capacity of being an individual or a firm, being a partnership or a body in corporate, or any legal entity. It can be a trust. So these are the different types of entities in India which can file a design application. Now design applications can be filed in these patent offices in India, and the receiving office would be Delhi, Mumbai and Chennai, and the examining office, so all the designs are received and examined at Kolkata office, being the Kolkata registry. Registration certificate is also issued by the Kolkata registry.
If you're interested in IP laws, do check out our courses on www.academyofpatents.com.